Where enforcement and real losses usually arise: illegal charter, records, and misaligned operations. Hello, yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss where the most serious enforcement and loss exposure usually arises, because this is the part clients tend to underestimate until after the documents are signed. The first point is blunt. Most enforcement tied to large turbine aircraft contracts does not arise because a purchase agreement used the wrong adjective. It arises because the parties use the aircraft in a manner the regulations do not permit, or they document compliance in a way that the facts cannot support. The first and most common danger zone is illegal charter and disguised compensation for higher activity. FAA Safe Air Charter materials say illegal air charter poses a serious safety hazard and warns users to examine whether the aircraft and operator are actually authorized and who truly has operational control. DOT's 2021 consent order against Paradigm Air operators is a useful enforcement example. DOT said Paradigm engaged in air transportation without the required economic authority and ordered it to cease and desist while assessing a civil penalty. That is why clients should remember that the most dangerous contract term in business aviation may be the one that promises access without answering who is lawfully selling transportation. If a management agreement, lease, or use agreement is designed to create revenue or offset carrying costs, the analysis must begin with whether the operator fits Part 91 at all. The second danger zone is maintenance and records. Large turbine owners often negotiate very hard over price, but not hard enough over records quality and return conditions, as well as discrepancy reporting. This is a mistake because FAA rules make the records part of the compliance architecture. Section 91.417 requires an owner or operator to keep maintenance records. Advisory Circular 43-9C says a well-kept set of maintenance records is generally a good indicator of aircraft condition and specifically tells buyers to require production of those records before buying. When records and conditions drift apart, enforcement can follow. In Lawson versus Herta, mechanics discovered that the aircraft records did not match its actual condition. The FAA found 21 discrepancies, and the court upheld the agency's revocation action after false entries in logbooks and FAA Form 337s were established. The factual pattern was not a large cabin business jet sale, but the lesson applies directly to turbine transactions. Inaccurate records are not bookkeeping problems. They become certification problems. There's also another important current law point here. In 2025, the FAA consolidated falsification prohibitions into 14 CFR Part 3, Subpart D. Section 3.403 now prohibits fraudulent or intentional false statements, fraudulent alterations or reproductions, and knowing admission of material facts in documents submitted under covered regulations or kept to show compliance. Section 3.405 addresses incorrect statements or omissions that are material to issuance or continued validity. For transaction lawyers and operators, that means the compliance risk now speaks in one clear voice. Here's something to remember. In aircraft enforcement, a bad fact in a maintenance record can outlive a good contract. A third danger zone is title, liens, and post-closing assumptions. The FAA's clear title guidance explains that FAA records may reflect unreleased mortgages, tax liens, artisan liens, and similar documents. In a large turbine transaction, if the contract does not force documentary cleanup before closing, parties may discover after delivery that they bought an aircraft with legal drag attached to it. The fourth danger zone is cross-border movement and use restrictions. Even when a deal is domestic on paper, large turbine aircraft travel internationally. And contracts often say little about export control cooperation, sanction screening, country of operation restrictions, or who bears the risk if the aircraft becomes difficult to repossess, insure, or position. That may not trigger FAA certificate enforcement first, but it can trigger regulatory trouble, financing defaults, or immobilized collateral very quickly. So, where do most enforcement actions and major losses arise in this space? They arise at the seams. And, well, between purchase representations and actual records, between dry lease language and wet lease reality, between permitted reimbursements and disguised charter, and between nominal responsibility and real operational control. A practical example makes this vivid. Imagine a newly purchased large cabin jet with a polished purchase agreement, a management contract, and affiliated use documents. The owner wants to reduce carrying cost. Trips are sold informally through relationships. Pilots are sourced through the manager. The lessee never really controls the flight. Maintenance discrepancies are deferred for convenience, and the records are summarized optimistically. That aircraft does not have one problem, it has four: operational control, compensation for hire, airworthiness, and falsification risk. The preservation strategy is disciplined alignment. Define the asset precisely, make records, access, and delivery conditions enforceable, match every lease, management, and use agreement to the actual operating model, align insurance, pilot, and maintenance provisions across all documents, and assume that if the FAA or DOT reads the file after a complaint, the agency will compare the contract language to what actually happened, not what the parties meant in spirit. In short, the most important key contract term for large turbine aircraft are the ones that survive contract with real operation. Those terms protect not just economics, but legality. I'd like you to take this away and remember this. In large turbine aircraft contracting, the biggest risk is not a missing clause. It is a contract that describes a fantasy operation. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are always welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues and answer your questions with precision.